hearing of the appeal of Mauritius Shipping against Employment Relations Tribunal and others.
Good morning, Mr. Guthrie.
Lord, my lords, my lady, in this appeal I represent the appellant. The respondent tribunal is represented by my learned friend, Ms. Hafsa Massoud. The first co-respondent is represented by my learned friends, Mr. Shakil Mohammed and Ms. Dunu, and the co-respondents numbers 2 to 11 by my learned friends, Mr. Vimalin Reddy and Mr. Ashvan Lukraz.
Well, now, Mr. Guthrie, we'd like you to deal first with the point about promptness.
Yes, well...
And when I say first and separately, please.
Yes. Well, my lords, the fact the Supreme Court, as you know, dealt with it last, and that's what I had planned to do, but I'm certainly content to deal with it.
Well, thank you very much. We would find that helpful.
Yes. Oh, my lord, if I might make just the very general point, the appellants feel it a little hard to be accused of delay when they were within the ordinary and well-understood 3-month limit. And
well, is it a 3-month limit? Is it not a requirement to act promptly and in any event?
Certainly. We do, I think. I think your lordships will have picked up from my written case that we accept that 3 months is not a so to speak, get-home-free card if one does it on the last day of the second or the third month. But in this case, I think the appellant would feel it rather hard to be shut out when, having begun the proceedings within the usual 3-month period, the hearing itself did not take place for a further 4 months. And the judgment was not delivered for a further 9 months. Litigation does take a little bit of time, and in the present cases, the application, as I say, was made within 3 months of the decision, and the delay has been explained. My lords, if I can ask you to look at the position as it was before the Supreme Court, at page 440 of the record, you will see that to begin with, it appeared that it wasn't being pursued. And so that page 418, I'm sorry, I said 440. 418. I'll ask you to look at that first. You'll see that in the course, this I should explain, is the course of argument before the Supreme Court at this hearing of the application for leave, where the initial reaction of the judges seems to have been this. It's between lines 10 and 20. Okay, so much for that. Now, this first point of court, we take it is no longer being suppressed, namely the application not having been made promptly. Then there's a subheading, which I'm not quite sure who said it, but first point no longer being pressed. Mr. Mohammed, who was for the first co-respondent, said that he would take the point nevertheless. If one goes to page 440, one sees that Mr. Gobin, who was at that stage appearing for MSCL, for the Shipping Corporation, did raise the question of there having been difficulties in obtaining the papers from the tribunal. And I think there had been a notice to put in extra evidence which was not pursued. But the fact is, and it's quite clear, and was before the Court of Appeal in Mauritius when the application for leave to come to your Lordship's board was being heard, that the appellant was doing its best to get the judgment and the record from the tribunal without any success. And those letters are at pages 471 and 472. See that on the 19th of May 2016, which is very shortly after the decision was delivered by the tribunal, the lawyer instructed by MSCL wrote to the Employment Relations Tribunal saying, please give me a copy of the record. That wasn't forthcoming. And he wrote again on the 6th of June 2016, which is the next page in the record, page 472. And he said that at that stage they had decided to apply for judicial review, which was their only recourse, and that the letter itself reads in the third paragraph, that application needs to be made promptly. I'm therefore renewing my request for all the documents. So the opponents were in a difficult position. It's not a straightforward case, as your lordships will have appreciated, so far as the law is concerned. And they did their best to get the record.
Was it essential to have the record before proceedings could be commenced?
I wouldn't have thought, with respect, my lord, they could be criticised for taking that view, bearing in mind they were within the ordinary 3-month period. What does seem to have been a pity is that these letters were not exhibited to an affidavit before the Supreme Court when they could have been. But counsel, who was then representing my client, took the view that he didn't have a procedural right to put in an affidavit because there was no affidavit to which to reply. And so they weren't before the Supreme Court. But
that doesn't really, I think, address the question. Why would it not have been feasible to draft proceedings and issue them without the complete record?
Well, they would have then have had, no doubt, to be amended to read or to deal with points which were...
They'd have the minutes of the proceedings by email to this.
Well, they hadn't the record. But I repeat, litigation does take a little time.
Yes, but these requirements to act promptly, as I know to my cost when I was appearing in judicial review applications, don't await the assembly of all of the material that might be germane. The requirement to act promptly is a pretty rigid one. And unless you can persuade us that it would not have been feasible to issue proceedings without the record, well, it doesn't seem to me that, reprehensible though it may have been for the tribunal not to yield up the record earlier, that is an answer to the promptness point.
Well, Lord, I have to ask for some indulgence. I don't think I can say that they could not have issued a pro forma notice of application or notice of motion paper.
Can I just ask when they had the judgment? Because it's dated the 9th of May.
Well, I assume that they got it with the record.
Yes, it was an award.
Yes, I mean, I don't think they would have had it in written form. Their friend says the same day. I can take instructions.
The 9th of May. Because that does make a big difference.
I have with me Mr. Dr. Lau Chand, who is
Yes.
he may or may not know the answer to that question.
Well, let's proceed on the premise that the judgment would have been available on the day that it was delivered, which would be conventional. Would it not have been feasible for your client to issue proceedings on the foot of the judgment?
Well, that's not what happened. Lordship, I can't wring an answer out of...
No, of course not. No,
the fact is, it does seem, I would submit, very hard on my clients that they should be asked to proceed with that kind of ideal promptness when they did do it within what's normally understood, and indeed appears to have been understood by the judges, because they said to begin with that point's not being pressed.
Well, that may have been the view, but quite clearly they reached an emphatically different view.
But if I mean, they do raise substantial points in this appeal.
Yeah.
And it would be, no doubt, also enormous assistance in Mauritius if the relationship between these rather opaque sections was explained by the board. It is an important case. I say it's 4 months till the hearing, 9 months till judgment. To shut my clients out on the basis,
Well,
what would have been satisfactory?
I think it's difficult to characterize it as shutting our clients out. They fail to comply with the requirement of promptness. And a matter that troubles us is that how one approaches the application of that requirement depends very much on the circumstances in the jurisdiction from which the appeal comes.
Well, my Lord, I might also note that that issue of promptness was raised before the judges in the Court of Appeal in Mauritius when they were asked to grant leave. I accept that this was a case where there was an appeal as of right, but nevertheless, there's no indication in the judgment of the Court of Appeal granting leave that this was an occasion in which the appellant would be in difficulty on that particular point. I think, while one gives respect to the local courts, the reason that they did give was that there was hardship on the individual employees. There was no evidence of that put before the court. And indeed, my understanding is that after the termination of their employment, they would in any event have been entitled, be bound to be on the workfare program in Mauritius. So they would have been in receipt of some funds throughout.
Yeah.
That was the reason the court gave, but it was, we would respectfully submit, possibly, I don't like to use I'm not meaning this pejoratively, but it is the easy way out to say, well, you weren't prompt, so we won't consider the...
Well, I think you would want to be fairly circumspect about making that submission.
Well, as I say, I don't want it in any way.
Yeah.
I just would respectfully suggest it would be unfortunate if...
I mean, this is an important requirement, one that is
Well, I know that
confronted regularly.
it's a requirement which has recently been before at least two of your lordships, my Lord, Lord Briggs, no, three of your lordships, my lady, in the Maharaj case, which was from Trinidad, when, just looking at the head note now, I think that case was dealing with an application outside the time limit.
Yeah.
But what is said is that the court should have regard not only to any reasons for the delay, but also to considerations of prejudice and detriment. Well, we have what we say is a good reason for the delay, because we were being, if you like, withheld from the record. And so far as hardship and so forth is concerned, that does not appear to have been a matter in which there was any evidence before the Supreme Court. So, my lords, I would strongly urge your lordships to hear the appeal on the merits. And
right. Thank you very much. We'll hear Ms. Masood on the issue of promptness. Ms. Masood?
Yes. This was, of course, not a point that was taken by the respondent tribunal before the Supreme Court, but it was a point that was taken by the co-respondents forcefully, and the court accepted, of course, the appellant did not act promptly. And we say that there wasn't no grounds of interference with our decision, and we make three observations. The first is the observation that, in fact, the appellant isn't challenging the Supreme Court's decision on the basis that the court heard in law, misdirected itself in law. Rather, the appellant does so on the grounds that the court's decision meaning that the appellant should not act promptly was irrational. And I take that from the notice of appeal at page 5. And to the extent that that's the challenge, we say that the appellant does face a rather high hurdle. Dealing with the substance next, we say there was no explanation from the court. And as to the prejudice to the co-respondents by reason of this was a consideration which it was entirely reasonable for the court to take into account in the context of a legislative framework to provide those in the position of co-respondents with a speedy remedy.
What do you say to Mr. Guthrie's point that because of inadvertence, material which might have been germane to the court's decision wasn't drawn to their attention, namely this correspondence in which the record of the proceedings was sought from the tribunal?
Well, the point was advanced by counsel acting for the appellant in the proceedings, and the court took the view that procedurally it simply wasn't hadn't properly been put before the court. And the court made the observation, or possibly it was one of the parties, that in fact the appellant had been on notice since August that the point was being taken by the co-respondents, and we can see that from the order which appears on page 408. Minute of proceedings, and one can see the date in the top left-hand corner, minute of proceedings, 8th of August 2016. And here it's recorded that the first co-respondent was objecting for leave to be granted on grounds that the application had not been made promptly. And the second...
Sorry, does that appear, please?
Third paragraph.
408.
Yeah.
Sorry, it's the third paragraph.
Correspondent. Yes, I see. Thank you.
And the other co-respondents had made it known that they were taking the point on the 12th of September, and we can see that on page 412. And it's the fourth paragraph on that page. The matter came before the Supreme Court on the 24th of November 2016. So there was ample opportunity, in fact, for the appellant to have dealt with the point, but they simply failed to do so. And there is, of course, the other point, which we don't take in our written case, but the second to 11th co-respondents too, which is, well, what did it matter? These documents wouldn't have added anything or improved the appellant's ability to plead their case. And I'll leave them to develop the point.
Yes.
And finally, we say that, that of course, if each party has dealt with a point last in their written cases, and that perhaps is a reflection of the way that the Supreme Court dealt with it. But of course, if the board accepts that there are no grounds for interfering with the court's decision that the application had not been made promptly, then that really is the end of it, because this is a sufficient basis for the refusal of the grant of leave.
Yes. Thank you. Mr. Mohammed?
My ladies, my lord, on the issue of properness itself,
Yes, that's all we want to hear you on at present.
this was a matter which I had insisted upon at the Supreme Court, even though the respondent at the time had decided not to press on the particular issue.
Yes.
Insisted on that. And I'd like here to refer over and above what my learned friend, the respondent, has stated. There were specific exchanges that took place between learned counsel appearing for the appellant then court at pages 439 and 443. And what exactly those exchanges show at pages 439 to 443 is that there was clearly no affidavit evidence before the Supreme Court. and therefore the Supreme Court could not therefore have considered appellant's counsel's contention from the respondent. My learned friend appearing for the appellant refers to a letter at page 471 of the Electronic Chronicle. But that particular letter at page 471 does not form part of the documents that was placed before the Supreme Court at the application for leave stage. And it was clear from the exchanges that their worships at the level of the Supreme Court had clearly explained to counsel appearing for the appellant there that they could not take judicial notice of the delay. It was open for counsel appearing for the appellant to ask for leave to put in an affidavit, since it was already clear from the very outset, from long before, that the issue about delay was going to be pressed upon, and therefore it should have applied for leave to put in a new affidavit to explain exactly why there had been a delay, which
Well,
he did.
that's partakes of something of a technical point, does it not? I mean, now we know that there had been a request of the tribunal for production of the record of the proceedings. And if matters had progressed in a regular fashion, the Supreme Court would have known that.
In actual fact, I would also like to refer in answer to that particular query at pages 11 of the electronic download, where we see the affidavit of the representative of the applicant. And in that particular affidavit that runs from page 11 all through to pages 6, we will clearly note, my lords and my ladies, you will see that at no point there can it be said, therefore, that the record that was being sought for was necessary or really important for them to have their possession in order to put this affidavit together. There was no reason. Now, it is clear when one looks at that particular affidavit, the background, be it all the issues raised in the judgment, everything is dealt with specifically in that affidavit. And it is at no place do I see specifically where the minutes of proceedings and the record is referred to. Here.
When did the record arrive, please?
The record arrived. I don't have the date. When did it arrive, the record? I do not have the date.
My instructions are the first week of July.
Thank you very much, Mr. Guthrie.
What I do recall is, as we went along before the Employment Relations Tribunal, after every session, the minutes of proceedings were sent to me, myself as counsel, and my instructing attorney after each session. So as far as we are concerned, we were in possession, and that is the practice before the ERT. That is the practice that we are sent emails, and all the minutes of proceedings are sent to us.
Sort of on a daily basis?
On a daily basis.
Well, it's quite clear from Mr. Guthrie's submission that that was a facility not extended to his client.
Well,
this is a
I
request.
assume.
That I think it may depend what is meant by minutes.
yes.
I'm not sure.
Yeah. The letter on page,
It is not sent to the client, but it is sent to counsel appearing
I see.
for the client. This is clear now. And it was my instructing attorney that made the request. I do recall that my learned...
Well, anyway, let's not get bogged down in that level of detail. Your essential submission is, I take it, that it wasn't necessary for the appellant to receive the record of proceedings in order for him to, or for it to issue proceedings.
Correct. And also I have made some, with regards to the special nature of this particular application for leave for judicial review. My lords, there was this issue where the Supreme Court has analyzed the issue of promptness and referred to certain authorities as to the importance of dealing with it promptly. The issue of hardship referred to by my learned friend appearing for the appellant. But in this particular case, I think it's very important to refer to the Hansard. At page 1082 of the electronic bundle.
Yes.
1082, there is reference, which is made in the first paragraph itself, when the legislator came with the amendment in 2013. And in the first paragraph at page 1082, there is reference, I'll refer specifically to, and I quote what was said before the National Assembly at the second reading of the presentation of the bill.
Well, what's the point, before we look at this, what point do you seek to...
What I'm trying to make here is that the reason why there was a change of the law in 2013 was precisely because prior to the 2008 legislation, the Employment Rights Act and Relations Act were brought in, there was the Termination of Contract Service Board that existed under the Labour Act. And the Termination of Contract Service Board dealt with all matters pertaining to redundancy, as opposed to the Industrial Court that dealt with all matters of unjustified dismissal. But it took a lot of time to go before the Termination of Contract Service Board. And sometimes it even took years, 10 years, 15 years. They had to have prior approval of the Termination Contract Service Board before making anyone redundant for economic reasons or structural reasons. But in 2013, the legislator decided that we had to do things differently to what was the case under the old law. And it was a post ex facto verification. But the legislator this time decided that you could make someone redundant provided you followed what was provided for under the law, but the Employment Relations Tribunal was given in law a certain number of days, 30 days within which to come up with a decision as to whether or not the decision to make redundant was justified or not. Therefore, in light of this particular context, the legislator wanted things to go fast, not to penalize in any way employees that were made redundant, that the employees could obtain redress and compensation as soon as possible.
Yes.
Therefore, in light of this, if we are to stick very loosely to the concept of 3 months, then the whole idea of what the legislator wanted is cancelled. So it is, therefore, this was a matter which I had myself referred to and raised before the Supreme Court. And the Supreme Court took note of that. And this, in my humble view, added credence to the whole idea of promptness having to be...
Well, it enhances the need for promptness.
Correct.
Yeah.
Yes, Michael.
Right. Anything else then?
That will be the only thing I wanted to refer to.
Thank you very much indeed. Mr. Reddy?
My lady, my lords, I will certainly join the submissions of my learned friend for the respondent and my learned friend for respondent number 1. The only point that we will add is a point that we have taken in our written case concerning the necessity of having access to the record in order to prepare the case for judicial review. The point that we have taken is at page 692 of the brief before you, and it is at paragraph 67. The simple point that we make, my lady and my lords, is that before the tribunal, there were extensive statements of case that were exchanged between the complainants at the time and the appellant, who was then the respondent. And the points that were taken in those statements of case at that time, and if I could refer your ladyship and your lordships to page 51 of the brief, which is in fact the statement of case, page 51 of the brief, which is in fact the statement of case of the correspondence numbers 2 to 11 before the tribunal.
Sorry, could you give me that page number again? Was it 251?
It's page 51.
51, thank you.
Yes.
And it starts on page 49.
The statement of case starts at page 49, but the essential point is at paragraph 5 of the statement of case, where the complainants numbers 2 to 11 set out what were their grievances. And your ladyship and your lordships will note that the grievances of correspondence numbers 2 to 11 were precisely the matters that were eventually discussed before the Supreme Court. There was the grievance about whether proper consultation had been had. There was the point made about the requirement of notification, and the broader point about whether the redundancy or reduction of workforce was justified in the circumstances. So the essential point that we are looking to make here, my lady and my lords, is that all the documents that were necessary for the appellant to prepare its case, its application for judicial review, would have been available to the appellant at the time that the matter was being heard before the tribunal. And for the purposes of that argument, I will also refer your ladyship and your lordships to the extensive replies of the appellant to the statements of case of the correspondent number 1, as well as correspondence numbers 2 to 11.
So they'd have all the written pleadings.
Yes.
But of course, at that stage, they wouldn't have the judgment. But we now know the judgment was obtained on the date of its
The 9th of May.
handing down.
This is exactly the point, my lord. And all the documents, in fact, that are before your lordship would have been available to the appellant from the time that the matter was before the tribunal, except for the award, which was communicated.
And it's clear from 472 that they weren't complaining about not having the minutes. I'm just wondering what, apart from the minutes, would relevantly be missing.
Could your lordship...
What, apart from the minutes, which
Yes.
they weren't complaining about not having,
Yes.
since they got them by email,
Yes.
would be additionally part of the record?
Yes. Yes. And all these matters that have been canvassed in the appellant's affidavit before the Supreme Court are very much the same matters that were canvassed in their replies to the statements of case of the correspondence before the tribunal. That would be the only point, my lord, that I would wish to add. We stated perhaps a little bit hardly or harshly in our statement of case that it was a red herring, that the record would have been necessary. These would be my submissions, my lord and my lady, unless I can be of further.
Thank you very much. Mr. Guthrie, we'll hear you
Yes,
in response to those arguments.
My Lords, there is one point which has only been raised this morning, which is the question of the daily minutes. Whereas my instructions are from Dr. Lao Chan that we did not receive daily minutes of the...
Well, it was clarified that this isn't supplied to the client, but supplied to the attorney.
Well, the reason one might think that they had something was the reference in the letter that
Yes.
472.
date only been communicated with the minutes of proceedings through email and not the complete copy. So it looks as if the minutes were communicated.
Well, it may look like that. I'm told by my client that that wasn't the case.
Right.
And obviously it's unsatisfactory if I can't nail that down.
Well, it is rather difficult to overlook the contemporary document, Mr. Guthrie, which, as my lady points out, is in pretty unequivocal terms.
Well, Lord, the chronology, judgment of the ERT was on the 9th of May. On the 19th of May, we wrote for the certified record. We wrote again on the 6th of June. It didn't arrive until the first week of July 2016. And on the 20th of July, we lodged our notice of motion, our motion paper.
What do you say to the argument that, irrespective of what you did or did not receive, you had adequate material to start proceedings?
Well, my lords, that may be something that I can't sensibly contradict. The fact is, the point was taken, and in the first letter, as you've seen, with the view of the need for promptness clearly in the appellant's mind, because he said the reason we need these is because we have to make our application prompt. The view was taken that we needed a certified record, and it didn't appear. Now, if that was a mistake, so be it. But respectfully repeat the submission that it's a little hard to accuse my clients of culpable delay if one looks at the overall time frame of this matter.
Well, this isn't a question of being accused of culpable delay.
Well,
The point is being made that you did not act promptly.
is that not the same thing?
No, it's not the same thing.
Well, it may come to very much the same thing if we made a mistake.
Yes, quite.
That's the most that can be said against us.
Thank you very much.
We did draw the matter to the, and if one looks again at page 440 of the record.
400?
440. It's the passage where, if you like, the mistake is explained. At line 29, Judge Hamoud says, was there anything legitimately in the way of you putting in an affidavit and explaining why you had taken so long? Yes, my lord, there would be a hurdle in the ways I cannot put in a second affidavit against my own first affidavit, only by way of rebuttal at a second affidavit.
Yes.
And,
Well, that's not correct, is it?
well, I'm afraid I don't think it is correct,
Yeah.
but the fact is, it was...
He didn't have to rebut his first affidavit. He had to explain the reasons for the delay.
obviously right, but
No, but you're quite right, Mr. Guthrie, to draw to our attention.
Well, you'll see from a little further down, I'm very sorry, my lord, my lady, to interrupt my learned friend when he's on his feet. He's talking about letters that was put in notice tender. If it was going to be an argument as to that, I was going to object to these letters being considered by...
Yes, I see.
So there'd been a mistaken attempt to put the letters before the court. They didn't get before the court. But that really seems to be about as far as that matter could be taken.
Thank you very much indeed.
Did you get an answer, Mr. Guthrie, about when the judgment arrived?
The judgment, I understand, was on the same date,
Of the 9th?
the 9th.
Yeah. And the award and the judgment are the same thing as
Oh, yes, I'm using the same word, yes.
It's Annex 10 or something to the affidavit.
We haven't accepted that we had daily minutes, but I can't take that any further on my view.
Thank you. We'll rise for a few minutes. The board has decided that the appeal should not be allowed to proceed further. We will give a judgment in due course, but in broad summary, the appellant faced a formidable hurdle here in seeking to persuade the board that the decision of the court that the appellant had not acted promptly fell outside the spectrum of reasonable decisions that the court could have made. We are satisfied from the material that has been presented to us and the arguments that have been made that that is an untenable proposition. Moreover, it appears to us that the appellant was fully appraised of and in the possession of all the material necessary to launch proceedings. It's unfortunate that the letters requesting the record of proceedings were not before the lower court, but we're quite satisfied that on the material which we have read and on the arguments that we have had, that it was quite unnecessary to obtain the record of proceedings in order to plead the case that was ultimately made. All of this, of course, is against the background that there had been a significant change in the relevant legislation, which enhanced the need to act promptly. But that provision in and of itself required the appellant to act promptly in this case, and the local court is in a much better position than are we to understand the significance of that requirement in the jurisdiction from which this appeal comes. But as I say, we will deliver a judgment in due course. Court is now adjourned.